First of all, thank you for including me today, and I've absolutely been sort of intrigued and entranced by the conversation so far. I told Severine before that I love the paper and the project as it evolves, and I've just been fascinated as well to hear Duncan's response to that. And I too often talk about Jane Anderson's work as a way to add some sort of complexity and nuance to our existing understanding of sort of copyleft and open access movements and the power of licensees and the potential variability of the conditions that we could place with a view to sort of context and mutual respect and an ethics of care. And so everything that has been said so far is just fascinating to me. But I think what I'll do is I'll take the invitation just to speak very, very broadly at a very high level about the paper on critical copyright and the politics of IP. I'd love to mention briefly some work I've done on a critical feminist approach to open access, because I think that really does wrap back into a lot of the substance of what we've heard from Severine. So first, just on this paper on critical copyright, and as you said, it really was an effort to kind of chart and draw the connections between critical legal scholarship with a capital C and arguably without, and the way in which that has been sort of pervasive in the intellectual property academy in the US in particular. And so this was actually a chapter that was for a book on critical legal theory. And the invitation from the editors was to talk about how critical approaches have informed IP. And even in that, the invitation was, a broad approach to critical studies. And then it was emphasized that this meant the need for just a critical element, a kind of an understanding that we need a theory that is reflexive about its own assumptions and aware about its own embeddedness in history and culture. And so I think that sort of self-awareness, that critical self-awareness, is something that's sort of a vital indicator of a critical stance. My entrance into even thinking about intellectual property was sort of with my graduate work, which began the very end of last century. And, there was, I think, clear that the main voices that were really entering the debate, entering the fray about intellectual property law at that time, and in response, I think, to the sort of radical paradigmatic change that was coming with the internet, were the voices of critical scholars and people who'd been influenced by the sort of 10, 15 years of critical legal studies in the US. And so it just seemed to me that the critical stance was very much embedded in intellectual property scholarship as it began to blossom at that moment in time. And so I think that thread has been pulled through really powerfully, meaning that this body of scholarship, which really only emerged at that time, sort of has all of the sort of indicators, if you will, of that critical stance. And I look back as well at, Felix Cohen's intervention originally, so sort of the legal realist intervention on the construction and the use of the property metaphor as a sort of deliberate political reification of a concept that was really just transcendental nonsense. This is something that we are just using the tools of law to make up, right? What is it? What are its boundaries? How do we define it? Who owns it? We're just using the law to make this stuff up. So sometimes I think there's no other area beyond intellectual property where the critiques that were launched against law by critical legal scholars are so obviously true and so almost indubitable. Like, it's just clear that this is a construct of law, and it's a construct of law that creates entitlements and it creates exclusions, and so it necessarily creates power and power imbalances. And we can work with the tools of the law to reconceive it. We can point to the contradictions, we can deconstruct it and reconstruct it in ways that will fundamentally change that balance of power. So I think that's really the main message. What I do is I go through the idea of law's reification as one sort of critical objection to law, and we see all those mesmerizing metaphors of copyright and intellectual property that Peter has written so powerfully about. We see the indeterminacy and the malleability of the legal constructs when we've got ideas like originality, the idea expression dichotomy, and all of these sort of legal fictions and fabrications that we have to work with to define the boundaries of this sort of illusory thing. We have all the mystifying, legitimizing legal rhetoric that we would expect to find. It seems complex. It's an elite, arcane field that people don't feel that they can enter into. And we see the politics, of course, of all of this in the way that intellectual property has always, but increasingly channels power and privilege in a culture where information and knowledge is of such enormous value. I then sort of chart the genealogy, if you will, of that critical intervention to show the way in which the realists emerging into the CLS critique, which became more of a sort of postmodernist, sometimes Marxist, less so critique. And then we also have the sort of breakaway of critical feminism, critical race theory. This is really where we see that sort of imminent critique of intellectual property, that really sort of radical challenge to the structures of IP, combined with what Balkan calls that strategic ambivalence, like the willingness to use law to advance a political project rather than to dismiss it and to throw up our hands in despair. And so I think that's kind of where the open access movement and Creative Commons and so on enter, at least from that critical angle, is to say, okay, so we can employ the tools of law, the tools of licensing and permission and properties and exclusion to include, to invert that power structure, to invite others in. And that's the revolutionary sort of potential of it. And I think that's what Séverine saw and still sees in it. But we also have, because politics and power are always at play, there was a moment in time where it suddenly became clear that this movement had become almost one that was founded on a notion of freedom that was itself a construct, right, and a privilege. And so it's, there was an unease sometimes. The sort of IP minimalists, the cry for Creative Commons and so on began to look more like a libertarian, everything is free for us to exploit and extract and use and enjoy kind of a stance. And the politics of the movement became a little bit more like, Laura Murray here called it, a sort of boys and their tech toys kind of a feel to it in the internet context. And nowadays we would call it like the tech bro kind of thing. And I see here's an attempt to kind of salvage that movement and redirect it towards the ideas of equality and distributive justice and access and empowerment and agency, at which it was, I like to think, originally aimed, and to which it can probably be effectively redirected.